the Valley Current.
Good. You're looking pretty young there, my man.
You too, sitting there with the bridge right behind you.
So tell me, I never really understood your journey of how you made it to be a patent prosecution lawyer. I know you became a member of the bar, I think, in Georgia, but tell me the journey that got you where you are today, because you've been doing this for 30 years?
Well, let's see. I got out of law school in 95. So, yeah. Thanks for reminding me.
It's hard, right? It's hard to believe that 30 years went by that fast, right?
Yeah, but I was an engineer for Panasonic, and I was designing cellular telephones, and that was what my master's program was it was at the cut of cellular technology, and that's what I studied in George Washington. So then I went to Panasonic, and there was a manager there helping a team design amps and in-amps cell phones way back in the day.
Those were like the bag phones where you had the big battery inside the bag, or were they actually the smaller devices?
We started with that, and then about the time I was leaving, we had one that was about this big, and we were highly competitive with Motorola at the time.
Right.
That was our big win there, was that phone, because it was a $300 phone. And
which was considered cheap, right?
Oh, yeah. So, but I was going to law school all that time. And then when I got out of law school, then I started doing patent work for Panasonic, and then a firm hired me in, and I got too close and fell in, man.
You got sucked into the vortex of patent prosecution work? Is that what happened?
That's what happened.
No, seriously, have you ever counted the number of patent applications you file, or do you try to do that? That's like McDonald's counting the number of hamburgers, right?
Yeah, I used to do that when I was younger, and then I just lost track about a decade ago.
I mean, it's got to be in the thousands, if not the tens of thousands, right?
Yeah, that, and I do a lot more trademarks. So I've got a bunch of trademarks that I filed. So.
Do you find that more interesting than the patent work? I mean, how do you come out on patents versus trademarks from a practice point of view?
I mean, it's the trademarks are a lot less mentally taxing, but like I tell people, they're deceptively tricky, and
right.
Really easy, and lose it by not filing it properly and getting the right recitation of goods and services.
Right. People make mistakes all the time, and I don't know what you've seen in terms of LegalZoom and Trademarkia and a bunch of these volume places. Yeah. I imagine you've probably fixed a few of those, but just generally, how do you feel about that kind of work? You know, what's happening in the volume digital practice of law online by non-lawyers. I mean, mainly not non-lawyers, I think.
Yeah, it is. And it's like I was looking at Trademarkia quite a bit, and we were looking at launching, and we did. It was called Circle That R. We launched a website and set up an engine where people could fill out the information. But, our key on it was we have attorneys that are reviewing this and filing for you.
Right.
As opposed to Trademarkia and stuff like that. They just prepare the app, send it back, and the other people have to file it and they have no legal liability. And
they're a typing service. Effectively, that's all they are, is a typing service, right?
Yeah. And now with AI and ChatGPT, everybody's going to be doing a lot of more stuff on their own.
Well, that's what's happening across the board. We see clients that say ChatGPT generated this analysis of my litigation case. Do you think it's right? And they want like a 5-minute review, and they want to pay for a 2-minute review. Yeah. And their view of life is, we really just want to know if this is right. And I just say, look, you probably can get a gig lawyer on Upwork to do that, but that's just not what we do.
No, I mean, it's like an associate wrote it, and I'm going to review it in detail because my name's on it.
Right. Well, you get slammed all the time with the view of, well, this sounds right. It looks right. Is there anything that is, like, sometimes the way it's phrased is from 30,000 feet in the air, You see anything that's going to make the plane crash.
Yeah.
And you're like, you can't make those judgments from 30,000 feet in the air.
No.
And I'm kind of curious if you're seeing the same thing happen in your arena of doing both patents and trademarks. Do you see that happening at some level?
I see it starting to happen. I've had a couple clients send me some stuff saying, someone wanted to do assignment of their trademarks, and they said, "Well, I got ChatGPT generated it for me." I go, "Yeah." It's like, you'll be better off if I just write one and give it to you and use my template, because I know that it has everything in there.
Right, but isn't there standard forms in the patent office that more or less dictate what gets done? I mean, doesn't the patent office issue a lot of standard forms generally?
They do.
What do you think, right?
They do. Yeah.
I mean, to some degree, they're trying to streamline all this stuff, right?
Yeah.
I mean, they don't like the fact that people end up filing custom stuff that then they have to read, right?
Yeah.
I mean, it's an interesting question. How much of law can be automated? I remember about 25 years ago, there was a guy named Siskind that wrote a book called The End of the Professions. He was a professor at, I want to say, a British university. And he said, AI was not in the picture yet. It was just about the digitization of information. He said people have information at their fingertips, so they're going to assume that they can act on the information, and they don't need lawyers to do anything. They can do their own stuff. Yeah. And there are people that attempt to do their own estate plans. They try to do their own corporations. They try to do all their own contracts. And I think there's a certain trend that's playing out where they call it access to justice being reduced in price. But I think the judges are going crazy with pro se litigants who are just filing all sorts of stuff, right?
Yeah. Yeah. I mean, you got to shepherdize all the case law and all of that stuff. And you need more than what you type in to ChatGPT or whatever to really generate a solid case. I mean, you got to know the parties, you got to listen to them and remember that, that they're probably lying to you. so
you have to figure out what the real truth is.
Yeah.
Right? I mean, in many ways, that is the hard thing. And the strategy is the hard thing, because the strategy really can't be spit out by a computer. Ultimately, that's really why people pay lawyers. But sort of tell me, when you kind of look at a particular field, and we've talked about this before, software has been under challenge from Supreme Court cases that have made it, pure software cases, very difficult to get through the patent system, or at least to enforce in court. Maybe more of them issue in the PTO than, say, the courts accept, because of a variety of cases, including the whole Alice line of cases. Yeah. But when you see something, do you immediately say to yourself, look, this is going to have a hard time eventually getting through the system? Like, how do you sort of abstractly look at variety of cases that come in? Like, even in the whole AI field, there must be just a ton of cases that people want to invent around AI now as a whole new wave of information, including, you did a patent application for me. I think you did a great job on it. And fundamentally, it was an idea I had as I was sitting in a classroom listening to a futures thinker talk about where things are headed, but he didn't have a specific idea of how to imagine what that platform would look like. And I did. And that's kind of what I preliminary wrote up, and you finished in a marvelous way. So thank you for doing that. But tell me how you think about it. Tell me how you think about it.
Well, what's your plan with it? Are you going to implement that, or?
Yeah. I've got some software people that are basically ready to create that dashboard and create that system. And I am experimenting, and I have experimented with all sorts of devices, all sorts of wearables, and what they do to provide feedback on how are you using your human potential. Like, we all have a certain amount of human potential. We all get, maybe lucky, if we're lucky, 100 years of life. So we all get basically, 12 months a year, 100 years, 1,200 months of life. You can do the calculations You can say a third of it goes to sleep. I don't know if that counts. And I've lectured about this at Stanford. And a third of it goes to all sorts of things like hygiene and, brushing your teeth and cooking your meals, right? There's a ton of stuff. And maybe a third of it goes to thinking if you're lucky. Yeah. You actually get to do some deep thinking with a third of it. That's not really a lot of hours.
No.
But how do you extend that human potential with the aid of all these wearables that will give you feedback about what is the time of day, for example, when you are most productive and you're most able to connect the dots of your thoughts. And if you actually track various statistics, as I do, with a variety of wearables, you might discover that you're more of a morning person and you get your best work done, which I do, from like 5 a.m. to about 8 a.m. For other people, it might be, 8 at night until midnight. Of course, I had law partners who used to wait right until 11:59 p.m. on a federal filing before they would get work done. But you could try to track that, and then you could build a dashboard that pays attention to how a team actually performs or fails to perform because of that kind of tracking, if you get the gist of what I'm saying.
Yeah.
So
and I think that's one of the, as I was going through it, I think that's one of the most patentable aspects on it is actually having all of your milestones, knowing what they all require and rearranging those so that, okay, we'll do this one first because it looks like you're not on top of your game. So this one's going to require less mental activity, and then do this one at 8 o'clock tonight when you're right. I think that's a good avenue on it.
But a lot of people, they're not even introspective enough to realize that they should be paying attention to that data. Like, you should pay attention to your sleep data, and you can buy almost any wearable. Samsung's got a pretty good one that you wear it at night, and it'll tell you how many hours of sleep did you get and what was the characterization of the sleep. Now, imagine taking that data and inputting it into how your cognitive work gets done the next day. So I didn't have a great night's sleep last night. Who knows what it was attached to? Maybe it had to do with things that we were talking about on this patent application. And fundamentally, I didn't have a great performance day today. And that really should be tracked in a way that teaches me. It pays attention to get a good night's sleep. I think I got 4.5 hours sleep last night, and it was not high quality sleep. The night before, I got a very high sleep score, the highest I've had in recent times, like 96 out of 100, which is a very high score. And of course, we track with each other. My spouse and I, Dr. Lee Suter, she wears the same watch, same brand, smaller wristband. Of course, she's a smaller person, and she shows me her data. We compare, and let me tell you something. For couples, if they're not getting a good night's sleep together, they may not stay married a long time. It may be a marriage predictor as well, to some degree.
Yeah.
I mean, it's the kind of thing that I think we're going to see more and more people realize that it's an important metric. And ultimately, it's a form of how do you get the best advantage out of the 100 or so years that we're given. Of course, 25 or so or more are taken up with school. And I don't know how long people are going to work, but a lot of people work now 50 plus years.
Yeah.
And it used to be more like 30, if you remember back in the day. But now it's much longer. But I don't know. How do you think about this whole area of software, hardware? Because these wearables are hardware, and they are giving feedback. They're like sensors in a race car, right?
Yeah.
They are giving a lot of feedback, right?
Yeah. Well, I mean, I busted my head for years now with this Alice stuff. And
right.
The patent office has it wrong. And I've told them, this whole argument that you're just using standard computer equipment and doing what they're supposed to do. And you're like, right. Well, yeah, you could say that about iron ore too, but people make cars out of it. And
right.
It's like once you put software inside a machine, it changes the way that machine operates.
Right.
And
right.
So don't give me this 101 rejection on it. You tell me if it's novel and non-obvious, because I put something in a machine, and that's just the same thing as putting gears and stuff together to either make a clock or to make a coffee grinder.
Right.
Okay? And it's different. And it's like, so just, the whole Alice thing has screwed stuff up so bad, and they are so myopic with it, and they won't get off of it. But the courts, as you said, I mean, the courts have dialed way back on that, and I don't think the patent office is doing us justice with it.
And there's been a movement afoot by a number of lawyer groups to try to get legislative change to happen, but so far it's completely failed.
Yeah.
And they, of course, call me all the time asking me for donations because they're a bunch of nonprofits that are doing it. And I've given some donations. And I do think from the bigger picture point of view, the question is, are we as a country becoming less competitive because there are other countries that are awarding patents and are allowing these inventions to go through, and they are respecting them, right?
Yeah. Uh-huh.
And so at some level, you might have an imbalance where the world looks at us as just a public domain system. Everything that's filed becomes a disclosure that others can use. And of course, we get lots of inventors and lots of small teams that say, should we rely on trade secret law and try to keep this stuff secret? And is that the better approach than filing a patent application? And you have to try to give them some advice about whether it's going to work or it's not going to work.
Yeah. I really wish we'd move more towards the Australian model, which is the self-examination model. You file the patent, they issue it. It's your responsibility to do all the searching, make sure that your claims are good. And because, otherwise you'll go to court and get it handled.
It's a little bit like the copyright system in a way, right? The copyright system sort of assumes good faith filings. The Copyright Office just records a bunch of stuff and puts it in an available, accessible online file in the Library of Congress. Yeah. And then this stuff gets litigated in court and really decided between counsel and expert witnesses and the like.
Yeah, and for the most part, these guys that are doing the examination, I get so irritated when I'll have a typo in a claim, pointed out in a paragraph where they have about 30 misspelled words because they don't speak English.
Right. Oh, inside the patent office, right?
Oh, yeah. Inside and the majority of people that are in the patent office are people that went through law school or are going through law school and couldn't get a job.
Right.
And that's where they end up. In fact, one of my partners, left to do something on his own, and he didn't work out, and he couldn't find a job, and he's an examiner now.
Well, you did some work in the patent office, didn't you, for some period of time?
No. I mean, I've interviewed and stuff out there, but never been an examiner.
I mean, that's got to be a thankless task, though, being an examiner, right?
Yeah.
And they measure your productivity based on how quickly you turn files, right? Isn't that part of what goes on?
Yeah, and that's why you get crap examinations with a few buzzwords that aren't even relevant, and it drives you crazy. And it's like, trademarks used to be easier. But now they've gotten on this bandwagon too, where they'll put their feet in and dig their heels in and say something's, substantially likely to cause confusion, and you're just like, you're out of whack.
Right.
And sometimes I just tell my clients, let's let it abandon and refile, and maybe we'll get a different examiner because it should go right through. And sometimes
does that work?
Oh, yeah.
Can you do that without disclosing that there was a previous rejection?
Yeah.
You're allowed to do that?
Yeah.
I didn't know that.
Yeah.
So you could basically ignore the rejection and treat it like, basically you abandon the earlier registration and then just file a new one.
Yeah. Because the examination is so subjective.
Wow. I had no idea that you could do that. I thought it's a little bit like asking for reconsideration and you have to disclose the earlier rejection.
No,
so you could play roulette then with the examination system, right?
I've had countless of them go through. I mean, the most recent one was for Aikens Ford here. They're taking their $75,000 Ford F-150s and they run it through their Wild Willie's shop to customize it for people, and they sell it for $150,000.
Okay, and they brand it. How do they brand that? What do they do with the branding?
Well, one of them is covert, and they just put different colors, different lifts, different types of ornamentation on it.
Right.
They'll murder them and make them all black. And of course, here in Georgia, they make them red and black for the Bulldogs.
Right.
But covert, I fought that for a year, 2 years, and the examiner was citing Nissan that was generating undercarriage protection for the cars, because if they go over a bump and a speed bump, it could damage it. And I'm like, it's completely different. It's like, well, it's a dealer. And I'm like, well, no, it's an auto manufacturer. So my guy's a dealer and he's selling trucks. And I finally just said, let's refile it. We refiled it and went right through.
Wow. That's interesting. And there isn't any argument that some litigant can make down the road that, hey, it was not full candor here to the office. There was a previous rejection. You should disclose that. That's not something that plays out just generally. I'm kind of curious how you think about that.
Haven't seen it.
Yeah.
Okay? But, it's a presumption. It's presumed valid.
Right.
And the courts would say, well, you've got to go through the USPTO and have it canceled.
Right.
And then, of course, any good litigator is going to find that and pull that up.
Right. But somewhere in this, conceptually, you're kind of hoping to get to the 5-year period where the registration becomes incontestable, right?
Yes.
And then, defer any litigation, if you can, to that 5-year period, right? That's a key thing. And then the question really becomes, can they dig out that previous rejected application and then somehow try to create an argument even after 5 years? Like 5 years, you'd want to be able to say it really is incontestable, right?
Yeah, but it's really just incontestable-ish.
Yes, right.
It makes it harder to get standing to file.
Right. So when you just generally try to counsel various clients, just from a generic high-level point of view, about, hey, I got a software hardware invention. I could keep it secret for a while. Maybe I could license it under trade secret law. I don't know whether I'm going to create an operating business or not. Maybe it's a licensing business. Of course, it takes a lot to create an operating business, and you have to typically go out and get either venture capital or friends and family to put some money in so you can garner some advertising and generate some marketing and so on. And we know distribution is a very hard thing to do, even in the age of Amazon. How do you counsel them on, well, you really should get a patent so you could say patent pending? The provisional is easy. Explain to people how easy it is to get a provisional in terms of just getting a filing date nailed down. What do you do? Tell people how you do that.
I tell most people, it's like, look, a provisional application isn't really a patent application. It doesn't get examined.
Right.
If you're, a mom, stay-at-home mom, and you've decided that you have a new mop that's going to like revolutionize the world, and you want to get a patent, I generally will tell them, it's like, look, you're going to be looking about at $8,000 to $10,000 here.
Right.
That's a lot of shoes for baby.
Right.
So what you can do is you can hold on to that money, file a provisional, and try to market the snot out of this thing and see if it gets traction. And then if you get traction, then let's convert it over to a regular patent application. Right.
You're saying to them, get on the Amazon system with a prototype or something that shows whether the dogs will eat the dog food.
Yeah.
You think you've got a great dog food product. I was talking to some entrepreneur today, and they said, oh yeah, my wife baked some great things out of the exhaust from the fermentation process of the husband who does his own beer. And there's like frothy stuff, I guess there's a bunch of waste. And they took that waste and turned it into a baked product that they could turn into like dog nibbles with whatever else they were throwing into the mix. And they were like, hey, we want to go to market with this new dog food that has this filler, which is basically brewer's waste, the stuff that you would otherwise throw away. And we think the dogs will eat the dog food. I said, well, have you tested it with some dogs? And they're like, no, don't you have to go to a kennel and see if the dogs, like do an A/B test where you have a can aeration is what I remember as a kid of what dogs would like out of a can. And this dry dog food where you put a little water in it and it expands and apparently gives them nutrition. I said, don't you have to do that? And you're kind of saying the same thing, right?
Yeah. But now for larger companies, I just tell them, I'm like, it's like you're hurting yourself, because when you file, you give me a disclosure and you want me to file an as is provisional and it's not flushed out.
Right.
I said, we make our money by doing claims and looking for design arounds and figuring out how someone can design around this, how we can make your claims broader to prevent that.
Right.
And when you file a provisional, you don't do that. And you
Right.
sit back on your laurels and you think you have a year to wait until you convert it over. But then if we go to file the regular application and we don't have enough disclosure in there to support what you got, you're not going to get the benefit of that filing date.
Right. So it's a kind of a catch-22. I mean, the patent office makes it sound like it's so easy to do and it's worth doing. But the truth is, you've got to actually have in mind what the target market is and where that niche will be, that your exclusive claims will actually matter in the actual commercialization of the product. And it almost requires you to do a bit of a market research about, well, what else is out there that might provide some of the same functionality, right?
Yeah.
I mean, to me, it's kind of a minefield, because we know there's lots of patent defenses, and we also know that patent litigation is very expensive, and we know that probably on the order of percentage, I'm going to guess that probably less than 10% of all the filed patents in the world get litigated, and of that 10%, probably less than 2 of the 10% or 20% of whatever that 10% amounts to actually result in wins for the owner of the patent, where there's actual money that's coming to the patent owner. And the price to get that whole thing through the system is just unbelievable, right? And most federal judges don't welcome patent litigation. They think it's very tedious. And they think the expert witnesses are very confusing. And they think the juries pick kind of the better story. They don't care about the document, and they don't care about any specific language that much. They pick a story. They like whoever tells the better story, right?
Now, I will tell larger clients, I mean, if you get ready to go to a trade show and reveal your product, and we don't have time to flush out a full patent, then let's get a provisional. So at least you got a little bit of a safety net. I said, but that's acceptable. The other
and
thing
you could theoretically say you've got patent pending just by having a provisional on file, right?
Yeah.
At the trade show, that might slow people down to some degree, right?
Yeah.
In theory.
Yeah. But the other thing about this AI stuff is people getting online, ChatGPT or whatever, and typing in their invention and having it generate a patent. You have no idea where that's going.
Right. You might have published. You might have effectively published.
The filing. And if someone in China gets it and files it before you, then they got an effective filing date before you.
Right. And people don't realize that does happen. The Chinese or Eastern Europeans or South Americans, or they're people that play chess, and they do it with domain names, and they do it with trademark registrations. They do it with a lot of things. It's a form, it's a high-end form of holdup, right? And it does play out. Now, you can set a switch within these AI systems that says, don't release this outside of the local control. Like, there is an internal switch that allows it to be locked. And now people are talking about maybe the future is you actually have an LLM on your local machine, not connected to the internet at all. And so effectively, you've got an enterprise version of some tool on a local GPU. They're talking about the cost of these GPUs may get down to like a couple of $1,000s.
Yeah, because the stuff that they spit out on ChatGPT and the speed that they do it, I'm like, wow.
It's shocking, right? You can't get someone to type that fast if you wanted to get them to type that fast. And I think there are federal judges that are experimenting themselves because they don't like the cost of having to delegate to a typist. I mean, if you honestly interview federal judges and you say, what is their biggest frustration? They don't want to type their own opinions. They want to dictate them. and they want a typist to do an accurate job translating them. And then they want to be in a position to see that copy quickly. And this probably is true in the U.S. Supreme Court as well. But if they actually have some version of a secure AI system that can do that typing to their particular, what I would call is not a large language model, but kind of a small language model that's targeted on their rulings, based on their PACER filings that are not broadly reaching out to all the other junk that's on the internet, I think they love it for just the ability to type. And I have to say, recently, I had one other thing. There was I'm an appellate specialist in California, and we talk among all the appellate specialists based on how briefs get done. And there was a guy who literally has like 55 years of experience. He's aiming to practice for 60 years, which means he's going to practice into his 80s. And he said the thing that shocked him about using ChatGPT, Gemini, Claude, Meta, Perplexity, whatever flavor you want to use these things, he said they do structure an argument in a way that's very surprising compared to trying to just do it from scratch yourself. He said it surprised him that he could take a set of issues out of kind of a record and just test, give me the structure of the best argument. And he said it was amazing what came back just as a skeleton for what needed to be thought about for the brief. And he said, 55 years of experience, he's probably done thousands of briefs. He said, you can't get the typing done as fast as that typing gets done.
Yeah.
And his argument was, well, maybe it's okay to use it to test the outline of the argument. Don't do any of the writing yet. Just test how good that outline can be. Basically, how good can the table of contents be for that brief, and iterate on that and be persistent on that. And maybe there's some real value. He was not sure that it made any sense to let it do the research, although obviously Westlaw has now got an AI version, and Lexis has an AI version, and Casetext has an AI version. They're all going in that direction where all the legal research tools automate or embed AI to begin with. Are you seeing that in the patent area where you'd say, well, there are specific drafting tools that are saying, hey, use this when you do drafting in sort of a sort of mass filing kind of way? Or what are you seeing?
I mean, well, I'll tell you, my wife turned me on to it. And she said, you should use this to generate, posts and blogs, to push out your business. So I started doing that.
Right.
And then I just started experimenting with it. And when I get ready to write an office action mostly for trademarks and stuff nowadays, I will put in the scenario for it and let it come up with a good outline of the arguments and everything. Then I'll shepherdize the case law and everything.
Right.
It does a pretty damn good job.
And I think that's sort of what most lawyers are coming to the conclusion on. Yeah. And the real question is, are the courts going to recognize that we're in a transition period where these tools are getting better and better, faster and faster, lawyers are getting better and better, although they have to be very cautious and police very carefully all the citations that are used, all the quotes that are put in, all of the logic, you might say, that's embedded, and try to make sure that there isn't some surprise in there that's going to result in some flagged issue that says, wait a minute, this was a miscitation, because we're seeing a lot of that play out. We're seeing that sort of thing play out over and over again in the federal courts. Yeah. So tell me where you think this is all going to go. You've been doing this for 30 years. Congratulations, you're in your 30th year. Where you look forward 20 years, maybe you make it to 60 years of 30 years more of practice. I mean, you might be, but give me your vision of where you think the IP system is going, because clearly people want to do their own work. They don't like paying for legal fees. They don't like losing control to others. When you look forward, let's say you look forward 10 years even, where do you think this all goes in 10 years? How do you see it playing out for inventors and marketers and others that are trying to get some IP protection at obviously the lowest cost.
I think that you're going to have, a set of the young entrepreneurs and stuff that are going to delve into the ChatGPTs and the AI and stuff and start preparing and filing on their own.
At a younger and younger basis. We saw a guy that is passing on an MIT full scholarship, high school graduate, good high school. He got into MIT, could become an engineer and great education, full ride. He said, I'm just going to start my own company. I said, oh, you deferring for a couple of years? No. I told him I'm staying out of the college market. I think I can start a business, and I want to be a serial entrepreneur, and I don't want to lose those 4 years. I think if that was your son or my son or your daughter or my daughter, we would blow a fuse. You're not going to take a full ride to MIT? Are you crazy? Are you nuts? I mean, what planet are you on? But this kid very much was convincing me that he knows what's best for him and that he wants to be an entrepreneur instantly. He may regret it in terms of not having a full rounded education someday down the road, but he doesn't want to lose that 4 years. And I said, you got 100 years to live with modern medicine. He's 18 years old. He'll probably live to 118. What's 4 years to give up to really get a network out of MIT? The network alone is worth a small fortune.
Yeah.
But he said no. And his parents are living with it. His parents had tried to get him to change his mind. He won't. And get this, he did raise $1 million from friends and family for the AI startup that he's doing.
Wow.
And he has assembled a team. And he does have a prototype already.
Wow.
So your prediction would be like, Mom, well, that guy is like so motivated, he'll probably follow all of his own stuff. Right?
Oh, yeah. I mean, he's clearly smart.
He may regret it. I mean, he may regret not doing some delegation because, as folks like to say, when you delegate, you do elevate yourself to free up some of your time to do higher cognitive work, right? So in a way, we are just service providers, right? When people delegate to us, we're just the worker bees in the story, right?
Yeah. Well, hopefully he won't end up like Kelly at Cura.
Well, she's a smart cookie, so
she is.
I'm rooting for her to turn around, but we'll talk about that separately and kind of figure out what the right angle is, because I'm sure there was a portfolio there that could have been saved. Yeah, and probably should have been saved. And the ugly part of that for her and for everyone is there's a bunch of creditors that probably would have given her a lot of credit. And now they're going to question whether she was doing stuff that really wasn't very wise for the business and whether there's an alter ego claim. Yeah. And that's a risk. That's a real risk for her.
Yeah.
Right. But I'll stay on top of whatever I hear there and let you know what I hear going forward. Hey, thanks very much, Greg, for coming on. Thanks for all your hard work. You're one of the best patent attorneys I've ever worked with my entire life. So I highly recommend you. And if people need to reach you, what's the best way to reach you?
404-643-3430. Text is the best way.
You just send a text saying, hey, I was referred by Jack Russo. I listened to the podcast. I need your help. You spring to action instantly and you really get stuff quickly. So bravo to you for doing that. I really appreciate it. That means a lot
coming from you.
It does. And I know. And I do say it with all sincerity. So thanks very much. Talk to you later. Bye-bye.
All right, Jack. Take care, sir. Later.
Tune in next time on The Valley Current.